Hi, everyone. Good morning, good afternoon, good evening. I am Catherine Mattice, and I am the founder and CEO of Civility Partners. We are a consulting firm focused on building positive, thriving work environments. Sorry, I just wanted to make sure we were streaming. Normally it says, we're going live, and it didn't, but I think we are. All right. So just to introduce Civility Partners a little bit, welcome to Catherine's Corner. Civility Partners does workforce surveys. So we do climate assessments to figure out what employees need from their employers. And we use that data to create action plans for change and implement those action plans. Of course, we deliver a lot of different training programs in the realm of civility, shocker. And we also specialize in coaching leaders who have been accused of being too abrasive. And I have two guests with me today whom I'll introduce in a moment. Jenna and Anita and I are going to talk about some of the new California laws related to workplace violence and sexual harassment. And I guess I'll go ahead and jump in and introduce you all. So I think you all know me, but again, founder and CEO of Civility Partners, written 3 books on workplace bullying. I'm a LinkedIn Learning course author, an award-winning blogger and speaker. I'm a TEDx speaker. So I love to talk about creating a positive work environment and all the different which ways employers can do that. Next up, I'll introduce Jenna. So Jenna, I'll let you say hi and share a little bit about you.
Sure. Thanks, Catherine. My name is Jenna Leyton-Jones. I am an employment law attorney. I have my own firm, Leyton-Jones Law. I spent over a decade in the trenches defending employers in stressful and time-consuming employment litigation before I decided that I was tired of fighting with people and really wanted to focus on what I'm passionate about, which is the preventative side of employment law and helping companies and organizations stay out of the courtroom. So I hung my own shingle, and now my practice focuses on day-to-day employment law advice and counsel, independent workplace investigations, and employee training. Thanks for having me. I'm excited to be here.
Yeah, thank you for joining. And Jenna and I have done several other webinars together over the years, and I can understand why you'd want to stop fighting and give advice. I feel like it would be exhausting. And Anita, go ahead and introduce yourself.
Well, good morning, everybody. Yes, I'm thrilled to be here, Catherine, with you and Jenna to co-present. I have an HR consulting firm, CorHR. I am a 30-plus year human resources professional. The first half of my career was in-house with very large employers, including quite a long stint with Siemens. And then I went to the consulting side in 2004 and opened my own firm 10 years ago. We work with professional services businesses to help them navigate our state's ever-changing, ever-complex landscape, and also coach and develop their management team to prevent unnecessary complaints, such as what we're going to talk about today, and as well create productive and accountable workplace cultures. I'm thrilled to be here this morning with you both.
Yeah, thank you. And the reason I invited both of you is you are very strategy focused, people focused. I don't know if you agree with me or not, but I have come to believe that there are sort of 2 types of lawyers and HR professionals. There's the super compliance, their sexual harassment training is very focused on the law and, is this harassment or not, versus talking about the culture and civility and respect. And then on the other side is people like us who are more focused on what's the bigger picture. Yes, what does the law say? And also, other than a policy, what else could the organization be doing? And just thinking outside of things. I don't know. Do you find that too, or is it just me?
Yes, I'll just jump in there and say that one of the reasons why our clients like working with us at CorHR is that we're not just rules people, right? We go beyond that because we realize that you need to have operational knowledge of how to apply these rules and how that works with your culture and how your culture can embrace being an accountable and productive workplace, for example. And the experience that the employee has is going to be with their direct manager. That's going to be their key foundational experience. Mm-hmm. That can either go well or not so well.
Yeah, and I'm 100% of the same mindset. I tell my clients on a regular basis that it's my very strong belief that your workplace culture is as important, if not more important, than your strict legal compliance, dotting your I's and crossing your T's. Because if you create a welcoming and respectful workplace culture, your employees are not, running to their favorite plaintiff's attorney down the street because they miss a meal break. On the flip side, if you have created a workplace where it's not a great culture, it's not a great place to work, employees are much more likely to look for opportunities to bring claims and to use your minor slip ups against you. So I'm very much am in the camp of workplace culture is of paramount importance in terms of risk mitigation and creating that congenial work environment.
Okay, yeah, definitely. And I wish more CEOs in the world saw things that way. We have a long way to go around HR not being a cost center, but in fact, investment that does have a return if HR is given the power to do the things that they need to be doing to create a good culture. So with that, let's jump into some fun topics around workplace violence. So Jenna, who's the lawyer here, she's going to give us some insight on this new law. And also, please do feel free to ask questions. We've got our chat open and we'd love to interact with you all. So ask questions, make comments. We'd love to hear from you. All right, Jenna, take it away.
All right. So we have a new law in California this year, SB 553. This new law requires employers as of July 1st of this year to establish, implement, and maintain an effective workplace violence prevention plan that contains specified information. So the new law it's actually very detailed. One of the more detailed laws that I think California employers have gotten in recent memory. And it requires employers to do many things, from recording information in a violent incident log for any workplace violence incidents, to providing effective training to employees on the workplace violence prevention plan, to maintaining records of workplace violence hazards, workplace violence incidents, records of training that has been provided, and then being able to make those records available to Cal OSHA upon request. These new workplace violence prevention plans requirements generally apply to any employer in California with one or more employees, but the new requirements don't apply to any employee teleworking from a location of the employee's choice or which is not under the control of the employer. And it also does not apply to places of employment where there are fewer than 10 employees working at any given time and that are not accessible to the public if that location is otherwise in compliance with all of the other illness and injury prevention rules. Employers are required to review their workplace violence prevention plan at least once a year, or when a deficiency in the plan becomes apparent, and after any workplace violence incident. Employers who fail to include a workplace violence prevention plan as part of their effective injury and illness prevention program are potentially guilty of a misdemeanor. So there are some teeth to this law. Again, this is just a very high-level overview of the new requirements of the new law. It's very detailed in terms of its requirements. So I definitely recommend that all employers take a look at this new law, spend some time reviewing it and making sure that you are going to be in compliance come July 1st. Now, the good news is that employers don't have to start from scratch in getting ready to be compliant with this new law. Cal OSHA has published a template for a workplace violence prevention plan that employers can at least use as a starting point when they develop their own plans. Employers should be aware that use of this template does not automatically guarantee that your organization is going to be compliant with the new law. And there's actually some disclaimer language on the form that says, employers are liable for any legal violations, regardless of their use of the template. So essentially, the template's a starting point. Use it as a framework. Right. Don't think that just because you're filling in the blanks on the template that you're going to be deemed to be in compliance.
That seems unfair. Seems like they should send out a thing that
California never makes it easy for employers. That's the bottom line. But at least we have something, right? Because they could have passed this law and given us nothing. So at least they're throwing employers a little bit of a bone with the template.
Oh, good.
Right.
I'm curious if either of you knows what inspired this law. Where did this pop up from? Do we know? I wish I would have researced that before. something happen and so it was being pushed, or?
I believe part of the inspiration for this law might have been highly unfortunate situations where people from the outside may have had domestic unrest, right, with an employee, and then were able to enter the workplace off the street and bring violence into the workplace that was intended against the person that they were having the domestic struggle with, but may have also resulted in other employees, innocent employees, being injured. And so the spirit of this law is really focused on how can people from the outside access your workplace, come into your workplace and commit a crime, commit violence, create a violent situation with either their intended target or any innocent employees in your workplace. So unfortunately, following the news, it's an unfortunate sign of the times, I believe, that was inspirational for this law.
What about, to your point, Anita, sometimes employees who feel wronged, instead of going to an attorney, will take justice into their own hands and go postal, as they say. So maybe that's some of it too. Have we not had a law around this stuff before?
True. Well, I know that, in the past we've had emergency regulations through emergency response plans through the IIPP, the Illness and Injury Prevention Program, right? Safety manual, whatever we want to call it. So I know you've had to have emergency procedures and trainings on how to evacuate the building if there's a fire, or what to do if there's an earthquake. Different specific industries may have also had workplace violence prevention in the past, healthcare being one of those industries, but this now touches upon every industry. So from that standpoint, that's a nuance that creates something really new for so many employers, including, as Jenna mentioned, even employers with just one employee who reports to the workplace.
Right. Okay. And then we have a question from Mary. Thanks for all your questions. Are there aspects of the law that include things like active shooter training? Jenna, maybe that's for you. Or
I think part of your workplace violence prevention training could certainly be active shooter training.
Okay. But it's not mandatory to have that
as far as I know, that specific type of training is not mandatory. Anita, do you know otherwise?
I don't believe I don't believe active shooter training is part of the mandatory training. I believe the mandatory training is more around the idea of what to do if someone is in your workplace, how to create like a safety exit or exodus for your employees, or where can they hunker down. I'll tell you, when this new law came out, we were letting our clients know that it would be very wise to do a walkthrough, right? A risk assessment walkthrough of your workplace. And if nobody on their current team would be experienced in doing that, reach out to your risk insurance broker and see if they have an expert resource to help out, or through your workers' comp insurance. And if not, there are safety consulting firms out there who are trained and can do a risk assessment walkthrough of your workplace. Because it really is a new lens that an employer is applying to make sure that they can create a program that's going to be in compliance with this new law.
Yeah. Another question I have is, do workplace investigators investigating things like a hostile work environment claim, do you also investigate workplace violence things, or is that that's a threat assess?
It depends on it depends on what the claim is. Some investigators certainly could investigate threats of violence. I would say personally, I don't feel like I have the background and knowledge necessary to do that kind of investigation. So I would want someone that has more of a background in that area to do that investigation. But I think certainly that could be a topic of an investigation.
Okay. Mary says many sheriff's departments will do the assessment for free. So there may be a resource. Reach out to your local sheriff's department. Jessica, I'm not sure if we can answer your question, but I'm going to put it up. And then I see a couple questions about getting the copy of the PowerPoint. I don't see why not, but I'll confirm with my guests here before we send it. So does either of you know the answer to this question? That they're visiting client locations, do we need to train them? I would assume the school's responsible for its own training, but I don't know.
I mean, I would think to the extent that your employees are visiting schools, you would need to work with the school to identify any risks and to incorporate that into your workplace prevention plan and to kind of incorporate that into your training.
Right. Okay. One of our clients is a security guard firm, and as part of their workplace violence prevention program, they are requesting a copy from each of their clients of the client's workplace violence prevention plans, because they need to know their role, right, in helping to create a secure and safe environment and the expectations.
That's a fair point. How are we working together on this?
That's
so
right.
All this conversation on workplace violence, let's go ahead and define it. So Jenna, I'll let you take this part on.
Yeah, so the new legislation actually recognizes 4 types of workplace violence that might impact a business or organization. So type 1 is violence that's committed by a person who has no legitimate business at the work site, and includes violent acts by anyone who enters the workplace or approaches workers with the intent to commit a crime. So this is kind of your, random person off the street walks in and starts shooting or does something violent. Type 2 is violence that's directed at employees by customers, clients, patients, or people that have or have had some other legitimate business with your organization. Type 3 is violence against an employee by a present or former employee, supervisor, or manager. That's sort of the classic going postal. And then type 4 is violence that's committed at a workplace by a person that doesn't work there, but is known to have some sort of personal relationship with the employee. So that's, a domestic dispute type situation. The guidance makes it clear that more than one of these types of workplace violence could be a risk factor depending on your organization. And I think for most organizations, at least, 2, if not all of them, are going to be possible. So I think it's really important to be thinking about all of these different types of violence when developing your plan.
I was thinking about type 1. I wonder, like the 7-Elevens, the gas stations that are kind of high risk. I'm assuming they all would have already had a lot of stuff in place. I wonder if this will create or make it better for those employees, that maybe there's more now to addressing violence from someone who's coming in off the street, or I don't know, just a thought I had while you were talking. I did want to go back and just talk about, so when we're talking about workplace violence, we're talking about the threat or use of physical force against an employee that has a high likelihood of resulting in injury, psychological trauma, or stress, regardless of whether or not they sustain an injury, an incident involving a threat or use of a firearm, and then the 4 types of violence that Jenna just talked about. So, as the workplace bullying expert here, I have always been seeking ways to get workplace bullying, into the law. And I was happy when California required the abuse of conduct, at least honorable mention in our harassment prevention training. So I'm just curious, this whole thing, I'm kind of laser focused on the threat or use of physical force against an employee that results in psychological trauma, or stress. That's where the bullying piece comes in. And I think about, I coach these individuals who engage in bullying. And part of that is to interview people who work with this person. And I've heard stories, for example, of this one guy would get up out of his desk and kind of lean over and get right in your face. And, people describe this kind of Dr. Jekyll, Mr. Hyde thing where his body language was really aggressive in that it wasn't just leaning over. It was, this like, like shoulders back, puffed up chest, facial expression that's very aggressive. Does that count as the threat of physical force that results in psychological trauma? What do we think?
I mean, I would certainly think so. I mean, obviously it's going to be circumstance dependent, but I mean, I would think certainly if there is a legitimate and reasonable belief that this person could become violent, yes. And that sort of segues into, I know something we're going to talk about in a minute, which is the new law on harassment TROs, but I certainly think, that could fit the definition of harassment as it's defined in this new law that we'll talk about.
Agreed. And I'm noticing that, the concern here, the threat, even just a threat, it's regardless of whether or not the employee sustains an injury.
Right.
It's unwelcome conduct, right? And the employer's first responsibility is to keep the workplace safe and free from unlawful conduct. But I'll tell you, unwelcome conduct is the slippery slope that leads to unlawful conduct.
Yeah. I mean, I've been talking for years about how harassment, sorry, we're going off topic a little, bear with me. But that harassment and bullying could actually be defined the same, because while harassment is focused on protected characteristics, it's unlawful when it feels like a condition of employment, which certainly if you're being bullied at work, it feels like a condition of employment, and a reasonable person would consider it intimidating, hostile, or abusive. And then there's this caveat that if it's aimed at everyone, it's actually not harassment, right? But if it is aimed at a specific class, then it is harassment and it's unlawful. So I guess sometimes I feel like I'm grasping at straws of like, well, maybe this is a way just to help. I'm always on a mission to help employers recognize, like you say, Anita, unwelcome behavior that creates stress is a slippery slope right on down to unlawful behavior and poor performance and turnover.
That's right. That's right. It can definitely hurt the workplace, and it doesn't need to rise to the level of being unlawful in order to hurt the workplace. You've got to hit on morale. You've got your good workers who are going to say, why are you allowing this to happen? I want to go to a workplace that has their act together.
Right. And that's what we saw in COVID. People were like, you're not paying me enough for this stress. I'm out of here. We have another quick question, kind of going back to the schools thing real quick. So we'll circle back for Michelle. She works in a practice management organization that supports independent practices. Is this similar to your comment of schools? I would assume so.
Yeah, I'm not sure what the exact structure or setup is, but I think that, if you have employees that are working off-site at various locations, whether they're schools or whatever the site is, that you are going to need to consult with those sites and the organizations there and kind of work together to assess the threat and to develop a workplace violence prevention plan that is realistic and takes into account the various sites that your employees may be working at.
Yeah. Thank you. All right. Keep those questions coming. We love the questions. All right. We're going to move over to talking about the harassment temporary restraining orders. So Jenna, take it away.
Okay. So in California this year, we have another new law, SB 428. Under previous law, employers were and still are authorized to seek temporary restraining orders and injunctions on behalf of employees who have suffered unlawful violence or a credible threat of violence that could be reasonably construed to be carried out in the workplace. This new law, which actually does not go into effect until January 1st of 2025, additionally authorizes an employer to seek a temporary restraining order and an injunction on behalf of an employee based on clear and convincing evidence that the employee has suffered harassment, that great or irreparable harm will result, and that the respondent or the perpetrator's actions serve no legitimate purpose. So I'll just read you the legal definition of harassment in this new law. Harassment is defined as a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person and that serves no legitimate purpose. The course of conduct must be that which would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress. Now, I think this is interesting because this definition of harassment in this new law is different than the definition of harassment that we have under the California Fair Employment and Housing Act, which, prohibits unlawful harassment in the workplace. But Catherine, like you were saying, requires that the unwanted conduct be aimed at or based on a protected characteristic. So essentially, we now have a new definition of harassment, at least for purposes of this TRO law. And I think this new law is really, again, aimed at preventing workplace violence and trying to give employers another mechanism to protect their employees, not just from threats of violence or acts of violence, but also from kind of these other, maybe more minor acts, which may escalate into violence. So under the new law, the employer has to provide the employee whose protection is sought an opportunity to decline to be named in the order. Even if one employee declines to be named in the order, the employer does still have discretion to seek the TRO on behalf of other employees. So again, I think this combined with the workplace violence law is just signaling that the California legislature is really taking the threat of workplace violence seriously. And I wouldn't be surprised if we see more legislation coming down the pike aimed at, addressing and preventing workplace violence.
Were employers already doing this? And do we see that what do we expect? That employers are really going to be leaning into this? Do we expect to see a big uptick in TROs related to this law, or have we already been doing this? I'm just curious about kind of the history and the future.
Anita, you want to weigh in?
Unfortunately, I don't have data on how prevalent employers seeking harassment TROs are. I don't have any data around that. It's an interesting question. A couple thoughts that come to mind is that harassment can occur in the workplace. It can also occur, we were just discussing a moment ago, you could have an employee who no longer works there who is still impacting the workplace and reaching out and perhaps making threats and what have you. So it's a relief to know that employers are now validated even more to pursue these temporary restraining orders to prevent something unwelcome like that from coming into the workplace. Mm-hmm. And that it's not necessarily limited just to individuals that are currently working together. Just as we said, you can get folks who leave the workplace but still reach out to your team and harass them and cause unwelcome conduct.
I'm thinking of an example of that I hadn't thought about in a long time. When I was internal HR a lifetime ago, we did have an employee who had worked through her way through the disciplinary procedure up to and including termination. And then she was really coming after me because she said her final paycheck and her W-2 was off because of I had claimed 9 and it should have been this, and you've been doing the taxes wrong this whole time. And I demand to speak to your bookkeeper. And I'm like, well, why don't you speak to an accountant first? And then if your accountant says you're accurate, then but I'm not going to unleash you on my bookkeeper. Not that I said it that way, but now that I'm thinking about it, she did harass me for quite a while. And I remember talking to my boss about it and I might get my own personal restraining order against her, but now the employer could be doing that on my behalf, I guess is the
right. We have a client where, sorry, Jen, I'll just interject along the same lines. We have a client where an applicant, in so many words, was really harassing the hiring manager for not having been hired into the position, as if that would really help your chances, right?
dodged a bullet there by
Continued to reach out and even show up unannounced at the workplace saying, I demand to meet with someone and understand why you didn't hire me. And so I said, just call the police, call the sheriff, call the local authorities. This person is trespassing. They have no right to be doing this. And, so it happens.
Yeah, so it does happen.
And I was going to say, I mean, in my experience, it doesn't happen very often. It certainly does happen. I think even with this new law, it's important for employers to view it kind of globally in conjunction with the workplace violence prevention plan, and not put too much stock in the TRO itself. Because even if they do, pursue and obtain a TRO, the reality is that a TRO is just a piece of paper. That piece of paper, if someone really is intent on causing harm and doing something, is not going to physically stop them from entering the workplace and doing something. So that's why I think having the workplace violence prevention plan piece of it, and having gone through the steps of assessing, other risk mitigation options is really important as well, and not placing, not saying, oh, well, now we have the option just to get a TRO, so we'll just do that, and we don't really need to pay too much attention to the plan because now, we potentially have this TRO. So I think it's really important to view them together.
Right.
Yeah, that's a good point.
Right.
I guess I hadn't necessarily before. This thing with this kind of new definition of harassment, do we think there'll be other laws coming down the pipeline in California using this new definition? I'm fascinated by the fact that we are finally using harassment in a more comprehensive way, at least in this little section of the law. I don't know. I'm curious. Maybe we don't have an answer, but I'm just curious on your thoughts.
I'll jump in. So I think it was, Catherine, you probably know better than I do. I think it was 2015 when abusive conduct training was initially mandated in California. And ever since that law was passed, I've gotten the question when I do harassment prevention training, is workplace bullying going to become illegal at some point? And my answer has always been, I expect that to be the case at some point. I expect there to be a private right of action at some point. And I think what we have now with this harassment TRO language, I think that's like one step closer to getting a law that creates a private right of action for this more generalized workplace bullying that's not necessarily aimed at a protected characteristic. So that's, I would not be surprised if we see that within the next few years.
Yeah. I'll say the woman who pushed forward having abusive conduct in the harassment prevention training, unfortunately, I cannot remember her name for the life of me, but she's a assemblywoman here in Chula Vista in San Diego, where we all are. So I do think that if she's still around, she probably is pushing for that at some point in the future. So I don't know, it's kind of excited, like, oh, it's from San Diego. Yay. So in that same vein, because I'm a workplace bullying expert who's been on a quest for 15 years to try to help get some laws passed around abusive conduct, just using that definition of harassment, again, I don't see employers going off and getting TROs due to workplace bullying, maybe, but I know this is really more related to that more clear violence. And that's where the wishy-washiness of the laws, where it's like, it's good to view the law, of course, and be in compliance, but also there's a lot of gray area in laws, and there's a lot of gray area in the way people behave. So just to kind of highlight workplace bullying or abusive conduct, and I was happy to see when AB 2053 came out that it is defined using the same three categories that I've been using for years. So that was exciting. But abusive conduct kind of comes in three forms. One is aggressive communication, which would be like that guy that I was talking about earlier, sending abusive emails or getting in someone's personal space. So it's the stuff that we can all look at and say, that's aggressive, maybe even feels a little violent or, dangerous. The second version is humiliating, pointing out mistakes in public, for example, or punitive punishment. You're 1 minute late, I'm punishing you. Sarcasm at people's expense. And then the third bucket is manipulation, giving incomplete information to do a task. For example, Jenna, here's 3 steps to get this done, but there's actually 5 steps and I leave 2 of them out. Or giving so much work that it's impossible to complete it, or constantly shifting someone's work environment or workload. So you can't perform well if today I have 5 client cases and tomorrow I have 25 and the day after I have 2. And so again, I'm looking at my thoughts around workplace bullying and this idea of harassment. And again, here's another legal definition of something that does, I think, really apply to workplace bullying. So I told you ladies I was going to shout workplace bullying every once in a while in our webinar. So, I'm not really, don't really have a point here other than to say kind of what back up what we're talking about, Jenna, that I think abusive conduct is, with these new types of laws coming, I think hopefully we get to that point. I don't know if you have any thoughts on anything I just said.
I'm thinking of the conversation that we had a bit offline before the call started, where organizations will promote someone who's done the job really well. They'll promote them into a first line leadership role, right? A supervisor or a manager, and not give them the training that they need to understand how to communicate effectively. Like something as simple as making sure you're giving complete instructions or complete information about the expectations or the requirements to do the job fully. And you just kind of unleash, I'll use your word, Catherine, unleash them on this group of people who may have been working at the organization just as long, if not longer, than their new manager. And then you get the reaction of, what is this? This doesn't feel cohesive. I'm left with questions. I'm not sure if there's an ulterior, meaning behind this or an agenda, a hidden agenda. And it will lead to complaints from employees that aren't necessarily harassment, but that are confusing and frustrating and create this kind of emotional turmoil. And then start to, if they don't feel like there's a safe way to express it, it'll just start to fester. And then at some point boil over. And someone will say, well, because I went back and pointed out to my new manager, to my new leader, that they weren't being effective in managing us, now this individual is retaliating against me. So the organization can unwittingly create a toxic situation or a really uncomfortable situation and potential liability when they don't ramp up a new leader, a new manager, a new supervisor, where they can take classes, understand what it looks like to be an effective coach, and carry out their responsibilities and have meaningful conversations and meaningful connections with their team.
Yeah, amen to all of that. Coaching, we need managers to be coaches, period, end of story. And coaching's not a natural skill. And so a big part of the work environment and being respectful is coaching. I'm just picking on that. Right. Your whole message, yes, but coaching is just something we see where, like you said, I come in, I'm a manager now. I don't really know what really is expected of me because no one's really told me. I have a job description, but I don't really know. Am I supposed to manage people who miss deadlines or coach those people and also coach people who are too sarcastic? And, I love sarcasm as much as the next person, but if it's too much or aimed at someone all the time, Do managers know to coach that behavior too? Probably not. Do they know how? Probably not. And so we talked about this earlier too, where, everyone says culture comes from the top, but really your employee experiences, culture comes from their manager. Culture does not come from the top. It really doesn't.
That's right. One of our clients had a new partner in an small engineering firm. And for whatever reason, the term snowflake came up, and he literally started pointing to his team and saying, are you a snowflake? Do you consider yourself a snowflake? Do you know what a snowflake is? And pointing to them one by one. He thought that he was being hilarious.
Mm-hmm.
His intent, I guess, was to kind of, socialize this term and say, we're not snowflakes here. Do you consider yourself? What do you think about snowflakes? There's no place in our organization for snowflakes. And what really helped in that scenario was that a more experienced individual contributor, longstanding, older, more experienced individual contributor, met with him offline and said, I want to chat with you. I know that you're new in this role. I think you had a particular reason to bring this up. How do you think it went over? And just kind of debriefed with him.
Love that.
And said, hey, you're really smart. I want to see you succeed. This is going to create a divide in the workplace. And so you need to think ahead. You need to be prepared for reactions of people and the body language, and go back and apologize if you've offended.
Yeah.
And that was really helpful. So even outside of training, you can have mature people in your workplace that can be wonderful mentors to your developing managers, your rising stars, your first line supervisors.
Yeah, I love that. I wonder, kind of going back to this law, does an employee, so if I'm being harassed using this definition, do I have to go to my HR and sort of prove that? What's the burden of proof, I guess, for an employer to say, yes, we will get that TRO for you?
I mean, I don't think there's a burden of proof for the employee, so to speak, in terms of triggering the company's obligation to act. I mean, I would go back to the definition of harassment, and if the company legitimately believes that this person is being subjected to conduct that seriously alarms or harasses the person. By the way, I'm not a big fan of using the term in the definition. They use the term harassment in the definition of harassment, but that's a story for another day. But I think, if the employer reasonably believes that the employee is being subjected to this conduct, and that a reasonable person would suffer substantial emotional distress because of the conduct. And if the person is actually suffering emotional distress, substantial emotional distress, that should be sufficient for the employer to act. Now, the law it's not mandatory from what I can tell. It gives employers the authorization or the option to seek a TRO. So at the end of the day, it's going to be the employer's option. Even if the employee, makes the showing, there doesn't seem to be anything in the law that mandates the employer to go seek the TRO. But I would say, if an employee is making the showing, then that's definitely something that the employer should be considering.
Right. Interesting. Okay. Any other comments or thoughts on this before we move on to the defamation? Okay, we haven't had any questions. Keep those questions coming. We'd love to hear from you. And once we're going to go through this, and then we're going to shift over to best practices, because as we've said, following the law is important, but there's a lot of other things we can do related to culture. So go for it, Jenna.
Okay. Next new law in California we got this year is AB 933. And this law provides certain protections to individuals who are victims of sexual assault, harassment, or discrimination, and who are subsequently sued under the state's defamation law. Since 2019, victims of sexual harassment have been protected from defamation claims in connection with complaints made to employers that are made without malice and based on credible evidence. So the new law we have this year expands the definition of a privileged communication to also include complaints made without malice regarding an incident of sexual assault or discrimination, as those terms are specifically defined in this new law. An employee who prevails in a defamation action brought in connection with one of these privileged communications is entitled to recover his or her reasonable attorney's fees and costs, plus treble damages or triple damages caused by the defamation action, and possibly punitive damages as well. So the statute really does have some teeth that are intended to make alleged harassers or discriminators really think twice before suing the complaining party for defamation based on their good faith complaint.
Does that happen a lot? I keep asking that question.
No, not to my knowledge. I can't think in all my years of practice that I'm aware of anyone being sued for defamation, but it does happen from time to time, but it's not frequent.
What do you think, Anita? Have you? I guess it's just another one of those laws where like, great, glad we're protecting employees, but also was this super necessary is kind of where I'm going with it.
You know, you would hope that there is protection, right? In these types of circumstances, I think it's one of those things where we're questioning, didn't this make sense even before we had to make it a law?
Yeah.
But then we go back to, common sense isn't always as common as one would hope. And so I suppose that's one of the reasons why our state has more laws than other states. It's not that there's less common sense in our state, wink, wink, but that I guess we're really strong in wanting to make sure that there is appropriate protections in place, even if we have to pass as many laws as we pass.
Yeah.
To provide that.
Fair point. All right, let's switch on to best practices. So I'm going to chat a second about just toxic behavior in general, which is harassment, annoying people, all violence, all of the things that we've been talking about, because I do think we often in these types of conversations villainize the person engaging in the bad behavior. But I always say the number one reason people engage in bad behavior at work is because the organization let them. So we need to be looking more at the organization. So this is a social phenomenon. This isn't happening in a vacuum. So we have the target or targets often have a counselor that they're talking to who's an ad hoc counselor, right? So in my scenario, when I was being bullied forever ago, I spent a lot of time in another director's office just venting, and she was venting. And so we were each other's ad hoc counselor. So that's the person I have to lean on. And then the person engaging in toxic behavior also has counselors. I know when it comes to workplace bullying, often they have advocates and allies in the C-suite because the people I coach are very high performers. That's why they've been allowed to act that way and even encouraged to act that way because they're getting promoted and acknowledged for the results they bring. And then we have the reinforcers, which is the word I use for witnesses. Witnesses are reinforcing bad behavior by not speaking up and saying, hey, that's not okay. So the silence really does have a very loud message. And of course, this is happening in the organizational context. And so what I'm always encouraging employers to do is turn those reinforcers into allies so that people who are being silent when they witness bad behavior become advocates and allies for not only the target or targets, but the organization and the culture that they are in every day at work. And so for me, I'm always talking about creating upstander training, as we call it, where people who are silent because they probably don't really know what to say or do are given some tools and permission by the organization to protect the work environment so that these toxic behaviors aren't leading up into unlawful behavior. So just something to consider as you're thinking about how to manage these laws and all the other laws we have in California. And then something else I would recommend doing as you're sort of auditing is looking at the risk factors. So for example, the EEOC, if you just Google EEOC harassment risk factors, there's they have a huge list. It's like 35 items of risk factors that research has shown creates or facilitates the opportunity for bad behavior to happen. In terms of workplace violence, of course, the availability of firearms and weapons in states like Arizona, you can bring a gun to work. That makes things very stressful. Or working in areas with high crime rates or high stress. That's where the going postal comes from. So whatever's in the law, which I don't know everything you're supposed to be looking at, but looking at the global picture is going to be really important. And also not seeing laws or HR initiatives is so separated. I hear a lot, well, we have a DEIB program. We're doing an employee engagement survey. We are looking at reward systems. We don't really use our core values, or we have a nomination program for core values, but that's kind of all we use them for. All of that stuff's interrelated. So that we really, as HR professionals, can't be siloing these things. Your DEIB program is related to the prevention of harassment, right? And so just kind of wanted to put that out there, because that's how I think about things, is just taking a more global look at the organization and looking at things like risk factors as part of this. So Anita, I'll let you take it away from here.
Okay, thanks, Catherine. So we've got a few tips to help prevent a workplace culture that can lead to certainly unwelcome conduct or elevate to unlawful conduct. And it starts with company values, as Catherine mentioned. This shouldn't be a PS. It shouldn't be an afterthought. It really should be something that is defined and with participation from all levels of the organization. And it should be focused around something unique that helps your work culture bond best and work to their best abilities. This should be reinforced during training for your leadership. It should be reinforced on performance evaluations. I'll tell you that if you haven't heard it before, certainly millennials and Gen Z, our younger generations, are the prevalent ones in the workplace, and they prioritize and value authenticity, truth, and connectivity. So your values really should reflect what inspires the majority of your workplace.
I'll just add a couple things there. Turning your company core values into core competencies is a great way to get those into the performance evaluations, so that everybody understands what behavior related to those core values means. Because we all have different ideas of respect or customer service or innovation, whatever your core values are, to really define those core competencies. Just like accountants have to be good at QuickBooks. That's a core competency. Have a core competency around being respectful. It's a similar, you can write it similarly.
Right.
And I just love, doing what I do, going into organizations that have a toxic work environment, and like, oh, well, I see your core values there. We haven't been living them, have we? We haven't been holding people accountable to them.
Right. Sometimes it's just an exercise at leadership, right? Yeah. Where they say, okay, we went away for a weekend and we were inspired and these are our values, but there's no input from the rest of the team. And okay, so how are you going to incorporate this really into your daily work life? It's not really part of your culture. It was a check the box exercise.
Yep.
For appearances, really.
Yeah. Yep. And that's, you've got to involve the entire workforce in creating core values. Or I find too, and you probably find this too, Anita, where maybe the leader who's founded the company 25 years ago is really stuck on these core values that were created, at some retreat like you're talking about. And it's like, but you're not using them. Let's get rid of them and start over.
Right, exactly. If they're not meaningful and they don't really, if you're not living your values, then they're not values.
Yeah, exactly.
Yeah. So, and then this goes along with just having a workplace of respect and, of course, DEI and B belonging as well. And again, the majority of our workforce, the millennials and Gen Z, they're counting on joining organizations that embrace this. They're very bright, they're very tech savvy, and it's very easy for them to call the internet and find an employer that does reflect the values that are important to them. So just like the example that we were giving, if a company really doesn't incorporate their values into their workplace culture, you're not fooling anybody. And goodness knows the employment market right now is in the employee's favor, not the employer's favor. So you want to do everything you can to attract and retain your valuable talent.
For sure. I feel like too that, we grew up without really having not workplace bullying, without talking about bullying really in school. But the younger generation, they had conversations about bullying in schools when they were in school. And I do think that's part of what's carried over is they've grown up with this idea of don't let people disrespect you. You should step in. Bullying is bad. And so they are less tolerant of bad behavior at work. And I think that's part of it. Just my little 2 cents.
Excellent point. This is something that we've mentioned earlier in our conversation today about reinforcing the expectation for leadership and employees together to have meaningful communication. Every workplace, every individual wants to feel really good about their contribution. And part of that is clarifying what does your role look like done successfully, and how does that add to the organization's, how does that feed into the organization's overall accomplishments, achievements, goals, and objectives. Everyone wants to feel good at the end of the work week or the end of the month or what have you about and feel like they can really experience the difference that they've made to improve things. And the easier the employer makes it for the employee to see that and be part of that and be recognized and rewarded for that, now you're creating a workplace of productive employees who are going to act as your stakeholders, have your back, not make frivolous complaints, and probably identify ways that you can continue to be competitive in your industry, in your field. Last but not least, embrace and encourage work-life balance. This is something that's valued across all of the generations at work right now. And of course, we had a taste of some of that during COVID. It's good to just recognize that, there of course, there's just more to life for each individual. Some folks, want to have, we appreciate wellness. We appreciate that we've got generations that may be in the sandwich generation or raising children. And when you allow your employees to be refreshed and take time to really consider what they're doing in their contribution and do it thoughtfully, they're going to be not only more loyal to you, but they're going to be more productive and creative and even optimistic. And goodness knows if you've worked with negative Nellies in the past, well, nothing will ever change around here. That's just how we've always done it. If you've worked with those people in the past, you know what a drag it is to be around them. No one wants a workplace full of negative Nellies.
'Tis true. And stress is certainly something that heightens, violence, harassment, bullying, whatever you want to call it. So people do need the opportunity to feel refreshed, because the more stress we carry, the more likely we are to lash out at the people around us. So with that, if we have, I don't see any other questions, please, we've got a couple minutes if you want to add them in the interim. I'll say, I also have a ton of courses on LinkedIn Learning around creating a positive work environment. So I encourage you to check that out. If you have a LinkedIn Learning or a LinkedIn Premium account, you can watch LinkedIn Learning courses for free. And a lot of employers also provide the subscription. So check with your employer if you have that or not. And then here's your SHRM activity ID. And we're happy to send you a little handout on developing a healthy workplace culture if you shoot us an email. Jenna or Anita, any final thoughts before we log off here?
Just make sure you're ready for July 1st and your plan is in place. It's now less than 2 months away, so that deadline is going to come fast.
That's true. I really enjoyed our conversation today. I hope all of you did as well. And Catherine and Jenna, thank you for the opportunity to co-present with you.
Yeah, this was fun. This was fun. We'll have to do these things more often. One other shameless plug. I have another webinar coming up around political discussions at work, because politics are at the forefront of everyone's mind these days. So wanted to invite you to that as well. So with that, thank you everyone for attending. And of course, we're all here on LinkedIn. If you want to reach out to Jenna, who is an employment attorney, or Anita, who is an HR consultant, please do reach out to them on LinkedIn. And if you want the PowerPoint slides, again, I'll have to confirm with Anita and Jenna that it's all right if I send them. And then if you would shoot me an email at that address there, we'll be sure to send them. And yeah, thanks. We're getting a lot of comments about how good our information was. So thanks, ladies.
Pleasure.
Thank you.
All right. Bye.
Bye-bye.